libreria dei podcast della Corte Costituzionale.
Thank you very much, Mr. President, distinguished guests. In the first place, let me thank you for inviting me to this wonderful conference. After two first presentations, I have an impression that everything has been said already. So I will try not to repeat what the other participants have already said. But I have to do one exception, and I would like to adhere to what President Lenaerts said, that it would be difficult not to underline on this occasion the immense contribution of Italian lawyers, Italian courts to the development of EU law, and even Italian citizens, because after all, it was the courageous Flaminio Costa who dared to challenge the electricity bill. And also, I would like to underline my experience with working together with Italian lawyers. It's a great honor and privilege to work together with Italian lawyers within the Court of Justice, Judge Rossi and Advocate General Giovanni Pitruzzella. I have been asked to take part on the panel National Identity of the Member States and Primacy of European Law. We agreed together with Judge Rossi that I will concentrate my intervention rather on the issue of primacy, whereas Lucia will focus on national identity. It seems to me that there is a broader issue behind the panel's title, phrased in this way, national identity, primacy. I think it reflects the question to what extent member states may invoke national identity in order to justify the non-fulfillment of obligations stemming from the treaties. In fact, the rejection of the principle of primacy is only one of many examples of the types of such non-fulfillment. Sometimes this non-fulfillment is explained by a simple reference either to the fact that certain competences of a member state could not be transferred to the Union under national constitution, or to the fact that the institutions of the Union, while exercising their powers, went beyond the competences that have been transferred to the Union by the member state. For example, and it's quite shameful, but the Constitutional Court of my country said that the Court of Justice, without making a reference to the court, that the Court of Justice encroached the competences of the member states, and therefore the decision of the court are not binding upon Polish authorities. In fact, the potential ways of the types of violations of EU law by member states are very numerous. They do not always consist of a breach of the principle of primacy in the strict sense. And for this reason, and in order to clarify our discussion, I would suggest to distinguish two meanings of the principle of primacy. The first meaning is a broad one. It covers all situations where a member state does not fulfill its obligation under the treaties. For example, non-compliance with the judgment of the Court of Justice, non-implementation of a directive. One can say that such a behavior on the part of the member states amounts to the violation of the principle of primacy. In fact, however, such a behavior constitutes at the same time violation of more specific provisions of the treaty, like non-implementation of a directive is a violation of Article 288. Similarly, one could say that the principle of primacy is violated when a judicial authority of a member state refuses to apply a provision of EU law endowed with direct effect, or applies this provision incorrectly by, for example, ignoring its effet utile, by not ensuring the respect of the principle of effectiveness of rights stemming from EU law, or refuses to interpret national law in conformity with EU law in order to avoid a conflict. I'm aware that each of these situations requires a separate analysis. In fact, the precise determination, the relationship between the principle of primacy and other principles of EU law, such direct effect, effet utile, effectiveness, principle of sincere cooperation, is in the first place task for legal scholars. Sometimes it has no significant consequences for practice of law. There is therefore no doubt that the principle of primacy to some extent overlaps with other principles. Especially interesting is the relation between primacy and direct effect. Some scholars are proposing that we should distinguish something what we call in French invocabilité d'exclusion and invocabilité de substitution, whether an EU norm simply make a national provision inapplicable, or instead an EU provision has to be applied. I would say that these two principles, primacy and direct effect, are very closely interrelated. One cannot properly function without the other. The sole primacy cannot exclude the application of a domestic provision without direct effect of the rule of the Union, because if the rule of the Union has no direct effect, then there is no need to invoke, make a national provision inapplicable. In my intervention this morning, I would like to speak about the principle of primacy in the strict sense of the term. It refers to the obligation to refuse to apply a national measure, national provision, that is contrary to EU law. This obligation is imposed on all authorities of the member states that apply the law, and it refers to the process of application of law. For those charged with applying the law, the principle of primacy is first and foremost a technical rule of conflict. It comes into play each time a national court, in the process of the application of law, faces a conflict between a provision of national and EU law. The principle of primacy means that in the event of such a conflict, a rule of the Union must be applied, sometimes by excluding application of conflicting national rule. And I'm sure that for most of you, the things I'm talking about are quite obvious. I will mention them only in order to be able to point out some issues that are still of concern of the courts of the member state. Maybe it was not mentioned, but in the presence of President Amato, it's worth to mention that there was intention to put the principle of primacy into the text of the Constitution of the Union. That idea was abandoned in the Treaty of Lisbon, but nevertheless, what is crucially important, there is a Declaration 17 which justifies that by the fact that this idea was abandoned, member states or anyone cannot challenge the existence of this principle of primacy, which was already developed by the Court of Justice. And I would like also to say that sometimes the textbooks, or even in the case law, we use the term supremacy as a term meaning the same as primacy. I would rather suggest that we should refer to the question of primacy, because supremacy suggests something which is not the case. There is no hierarchy between the law of a member state and the law of the Union. using maybe the terminology of the domain of law, which is very close to mine, which is private international law, primacy is like a conflict rule, conflict of law rule, saying that if there is a conflict, we apply this legal system. A normal, traditional conflict of law rules designates one applicable law between several applicable laws. And it's the same here with primacy. It says that for the sake of uniformity, equality of the application of EU law, if there is a conflict between a union rule and a national rule, we apply the rule of the union, but it doesn't mean there is a hierarchical relation between these two norms. Let me refer to a number of indisputable conclusions that can be drawn from the case law of the Court of Justice. So first of all, the primacy does not derive from the constitutional rules of the member states, but has its source in the treaties themselves. This means that the primacy of the Union is independent of how a state's constitution regulates the relationship between the law, the international law and domestic law. We all know that the relationship between international law, EU law, and national law is regulated differently in national constitutions of the member states. But nevertheless, from the point of view of EU law, from the point of view of the Court of Justice, it is irrelevant what method a given member state uses in order to provide a basis for primacy, provided, of course, that the union law actually be given precedence over domestic law. It is obvious, since otherwise there would be no uniformity of the application of EU law, as President Lenaerts said today, no primacy, no equality. Second, the principle of primacy operates from the moment of the entry into force of the union norm. It is irrelevant whether a conflicting national provision is prior or subsequent to the union norm. Thirdly, the principle of primacy applies also to all provisions of national law, including constitutional law norms. I leave apart the question of constitutional identity. Fourthly, a conflict between a domestic provision and a union norm does not invalidate the domestic provision, but simply precludes its application. Fifthly, the obligation to apply the union legal rule and to disregard, not apply the conflicting domestic provision rests with each authority of the member state responsible for applying the law, including administrative bodies. Of course, we have to bear in mind that only courts can refer the questions to the Court of Justice. And sixthly, each authority of a member state applying the law must have the independent power to refuse to apply domestic provision, and the Italian case that the references from Italy, started from Simmental, has very much contributed to this principle, that the process of application, a conflicting national rule cannot be applied. What are for me the essential elements of the principle of primacy? First, it is essential to identify that there is a conflict. A national court must ascertain that in given circumstances, the provision of EU law has direct effect. Otherwise, this provision would not be capable in itself of rendering a domestic provision inapplicable. In the recent decision of the court in Poplavsky II, the court clarified that the duty to set aside provisions of national law is restricted to those provisions of union law that have direct effect. Otherwise, the obligation imposed on national courts may be restricted only to the interpretation of national law in conformity with union law. Secondly, in order to identify the existence of a conflict, it is necessary to identify properly the scope of the application of each of these provisions. This concerns temporal scope, personal scope, and substantive scope. Sometimes the conflicts are false, and even though the wording of two provisions may suggest there is a conflict, but if we analyze carefully the scope of application, there is no conflict. The identification of the scope of applications is particularly important in the domain of fundamental rights and international law. The scope of the fundamental rights enshrined in the Charter is determined by Article 51, according to which the Charter is addressed to EU institutions, but also to the member states when they implement EU law. And there is a whole body of courts case law that interprets this provision. A national rule may be assessed in the light of the Charter, of the fundamental rights stemming from the Charter, only if the requirement stemming from Article 51 is fulfilled. Otherwise, there would be no conflict, since the Charter does not apply in a particular set of circumstances. Similar problems may arise in relation to fundamental rights and general principles of law as far as the personal scope of application is concerned. For example, in recent years, the court was called upon to ascertain whether certain fundamental rights or general principles may impose obligations on individuals. For example, in the case of non-discrimination by a private employer. Again, if the court finds that a given right does not bind individuals, the conflict between a domestic provision and EU law may be avoided. The identification of the scope of application is particularly important in the case of international law. And here it must be emphasized that the principle of primacy applies as a rule to conflict between EU law and international law. And I must admit that the role of Italian courts is particularly important in this regard. We had many references from Italian courts about the relationship between international law and the union law. And let me phrase a few remarks. First, the union itself may conclude international agreements. These agreements are part of EU law with all its consequences. This implies that the principle of primacy applies to the conflicts between obligation stemming from these agreements and domestic law of the member states. In the court's case law, we find many examples of judgments interpreting international law that was a part of union law, where the courts of the member states were in doubt as to the compatibility of national law with this international law. Secondly, in the case of international agreements which do not form part of union law, but which bind a member state concerned, a conflict may arise between the implementation of such agreements by these member states and the union law. The principle of primacy may apply in such situation as well. In general, these kind of conflicts are regulated by Article 351 of the Treaty on the Functioning of the European Union. It is a provision governing conflict between treaties, which distinguishes international obligation pre-existing or posterior to the entry into force of the union law. Furthermore, it distinguishes between international obligations towards third countries and towards other member states. In the second scenario, international obligations towards another member states, the principle of primacy should apply. Member states may not enter into international obligations towards each other which would contravene union law. In the case of international agreements to which only member states are parties, the situation is relatively easy. One has to analyze carefully the scope of application of this agreement and the relevant provision of EU law. If the scope coincides, there is a conflict and the principle of primacy applies. The best example is decision in ACMEA, which says that dispute resolution clauses contained in bilateral investment agreements between two member states are not binding because they are against the EU law. But the situation becomes more complicated in the case of agreements to which both the member states and third countries are parties. If these agreements are contrary to EU law, the essential question is whether the obligations that the member states undertook towards each other can be separated from the obligations undertaken by the member states toward third countries. If this is the case, the principle of primacy applies. Illustration, Comstroy, where Judge Rossi was judge rapporteur, where the court concluded that dispute resolution clauses contained in multilateral treaties can be distinguished between those clauses which concerns the relation between two member states and a member state and a third country. I know that we do not have much time left, so I would simply conclude by citing a passage from the judgment number 67 of the Italian Constitutional Court, and where I found a formulation which, in my opinion, should be included in every textbook on union law in all member states, that the principle of primacy of EU law and Article 4.2 and 4.3 in the Treaty on European Union are the cornerstone on which the community of national courts rest, held together by convergent rights and duties. This court, the Italian Constitutional Court, has consistently upheld that principle, affirming the values of its driving effects with regard to the domestic legal system. Within this system, the centralized review of constitutionality enshrined in the Italian Constitution is not an alternative to the widespread mechanism of implementing union law, but rather merges with them to build an increasingly well-integrated system of protection. Thank you very much for the invitation and your attention.